Good morning, afternoon, or whatever it may be, wherever you are. We want to welcome you to this week's session of current federal tax developments for the week of February the 9th, 2026. I'm Ed Zollers, CPA from here in Phoenix, Arizona, and we have a full slate of cases and guidance to cover today, ranging from an aggressive charitable planning strategy to specific procedural rules for research and development credits and ERISA beneficiary designations. We'll be diving into court opinions from the tax court, the Court of Federal Claims, and the Seventh Circuit, along with a significant field service advice from the Chief Counsel's Office that deals with a structure that we've actually talked about before. So let's take a look at our agenda. We're going to start with the Charitable LLC tax shelter, where this is going to be looking at Field Service Advice 2026-0401F. This is a major warning shot from the IRS regarding strategies where taxpayers transfer non-voting LLC interests to charities but keep control of the assets. The IRS is using the economic substance doctrine to disregard these transfers entirely. Next up, we're going to look at a Section 280 ERC bar for cannabis business. So this next is a decision from the Court of Federal Claims, Gravenstein 116 LLC versus United States. The court there ruled that a marijuana business cannot claim the Employee Retention Credit, ERC, because Section 280 Cap E bans all credits, even refundable ones, from those businesses that are involved in trafficking certain controlled substances. Next up, we're going to look at a TEFRA intervention case. This is a procedural fight in the case of Walker Church Green 819 LLC versus Commissioner. The tax court in this case denied majority partners the right to intervene late in a case to block a settlement negotiated by the tax matters partner. Our fourth development this week looks at research and development credit substantiation. In this case, we have a lesson on documentation for research and development credits in the case of George versus Commissioner. The court had to decide which came first, the research or the study. If your study contradicts your daily records, then the credit is denied. Next up, we're going to look at the question of supervisory approval of penalties. Something that's become a real issue in the past few years. And so we're going to check in on Section 6751B in the case of Palmwood Holdings LLC versus Commissioner. In this case, the tax court confirmed the signatures on an answer are sufficient to prove supervisory approval for penalties raised in litigation. And then finally, something we've seen in the past, unfortunately, happened this time as well. Look at an ERISA beneficiary designation snafu following a divorce. In this case, this is a case of Packaging Corporation America Thrift Plan versus Langdon, which is a cautionary tale from the Seventh Circuit. A fax request to change the beneficiary wasn't enough to override the plan's requirement for an online update. And the key becomes, who gets the money? Because obviously at this point, the original worker died, and that's where the fun starts. So opening up, we're going to talk about the significant piece of guidance from the Office of Chief Counsel. This is Field Service Advice 2026-0401F. This was released on January the 30th. Now, this FSA is a must-read because it provides a comprehensive roadmap of how the IRS intends to dismantle aggressive charitable planning strategies. One strategy which now seems like it might begin to be marketed to take over where the conservation easement shelters are falling apart. Specifically, we're looking at a structure involving the transfer of non-voting LLC units to a tax-exempt entity. Now, as far as doctrines involved in this case, the IRS throws the kitchen sink at the strategy. As we go through the next few steps, we're going to watch how they layer their arguments. We're going to use the economic substance doctrine to disregard the transfer entirely. We're going to use Section 704E to argue that charity is not a bona fide partner. We're going to then apply the assignment of income doctrine to reallocate income back to the donor. And finally, they're going to deny Section 170, charitable contribution deduction, based on a lack of donative intent and substantiation failures. The key warning here is that estate planners and advisors have to be concerned about retaining dominion and control over assets that have nominally been moved to charity. This is the magic where we give it to charity, but you keep full control. Well, didn't work so well in this case, at least per the IRS. So let's look at the mechanics right now, the factual background, the strategy. We have a taxpayer husband who established an LLC, LLC number one, and transfers non-voting interest to a tax-exempt entity that's labeled inside this advice as Organization 1. The stated goal is to fund a donor-advised fund. Now, the promoter sold this as a way to earn investment income in a tax-free environment. The taxpayers explicitly admitted this was a primary intent: tax-free growth. The key we're going to look at here is whether control versus the actual economics of the situation. For control, the taxpayers retained 100% of the voting interest and management control. They controlled the checkbook. The economics said the operating agreement was drafted to allocate a massive percentage of income, percentage one, to tax-exempt entity, while the taxpayers received a tiny slice. The argument being, of course, is that income is allocated to a tax-exempt who's not going to pay tax on it. Only a small amount goes to the taxpayers. What was the reality of the operation? Well, this is where the facts get bad for the taxpayer. Despite the transfers, the taxpayer kept signatory authority, and crucially, they used LLC funds for personal purposes. They would withdraw cash from the LLC and then later paper over those withdrawals as loans to qualified borrowers via an amendment to the operating agreement. So, big problem. The result, the taxpayer reports a small share of income or loss, while the bulk of the invested income theoretically flows to the tax-exempt entity, escaping taxation. This is, on paper, it looks this way. The reality is going the other way. As you might guess, the IRS not thrilled with this structure. Let's go first with the first big attack and what the IRS considers the principal one, the economic substance doctrine analysis. The IRS's leading argument is the economic substance doctrine under Section 77010 applies. They aren't just adjusting the transaction, they're disregarding the transfer of the units entirely, which under an economic substance attack, they would be allowed to do. Now, to come under that section, you have to pass a two-pronged test. First, the subjective inquiry part of the test. The IRS looked for a valid business purpose, and they found none. They concluded the structure was designed solely for tax savings, specifically the double benefit of an upfront deduction plus tax-free growth. Secondly, there was the objective inquiry. Did the transaction purposely change the taxpayer's economic position? The IRS said no. The husband remained in control of all the assets. The charity, referred to as Organization 1, had no enforceable rights in the asset. Its position did not change before or after the contribution. Thus, the key issue, domain and control, the unbridled use of the assets, evidenced by those personal withdrawals, characterized as loans, were taking the money, was fatal here. The IRS concluded that the transaction lacks substance and must be disregarded. As we would note, this is not a good set of facts to go before the court. Now, this is just the IRS's analysis here. We can expect that it's putting a little bit of a spin on this that's in their favor. But the reality is, if you're being marketed, your client's being marketed something that essentially says you could do this, make a gift this, take a huge deduction for 99% of the balance of your portfolio's value right now, and then turn around and just, take money out whenever you want. We'll just sign over and paper over a loan, and that'll work everything great. It's probably going to fall apart. I don't see that passing court scrutiny. Second, we're going to look at the rejection of bona fide partner status for the charity. So this is a backup argument. If economic substance is found, the court doesn't buy, we can throw it out under the economic substance statutory provision. And the IRS argues, even if the entity structure were to be respected, the IRS argues that the charity cannot be treated as a partner for tax purposes. And this is the Supreme Court's Culbertson test. Did the parties in good faith and active with a business purpose intend to join together in the present conduct of basically an enterprise? Yes or no? The IRS argues that charity is a partner in name only. And the FSA breaks this down into three economic failures. Number one, there is no upside, right? The operating agreement called for mandatory distributions, but the taxpayer manager simply ignored them. The charity received nothing. Now, bottom line, if it did work, you can't ignore things that are in the document. That's bad facts. Okay. Number two, no downside. The charity paid nothing for the interest and had no capital call requirements. They had zero skin in the game at the end of the day. And third, there was no realizable value. Because of strict transfer restrictions, the charity couldn't sell its interest. Without the manager's consent to distribute, the interest was effectively worthless. Now, you might wonder, why in the world would a charity ever let things go like this? I mean, especially the part where they're simply violating their mandatory distribution provisions. Why isn't the charity suing? Well, it turns out the donor advised fund here is a specially put together one that is, let's say, under control of a group that's not going to be too picky about enforcing the charity's rights. That's a nice way to phrase it. And that's why the DAF, that's also why there is a DAF sitting in the middle here. Because you'd have a real problem with this structure in most cases. At least I believe most attorneys that I've ever talked to about this suggest, a charity is going to pursue. If you are actually doing somebody here, let's say that we had given this to a major charity, major nationwide or, large local charity, they'd probably be taking to court over this thing. But that's why we have the DAF sitting in the middle. So we're not worried about the American Red Cross, getting upset and coming after us. Because the DAF simply, might be advised to give money to the Red Cross. But Red Cross doesn't have it right now. So conclusion is the IRS views the operating agreement as not as a partnership agreement, but merely a statement of intention to make a gift at some point in the future, but it certainly ain't happening now. Next up, let's go to another backup agreement here. This is the assignment of income doctrine. Since the taxpayers never actually parted with dominion and control of these assets, the allocation of income to the charity is viewed as an anticipatory assignment. The income must be taxed to the one who controls the asset. That is, the taxpayer in the IRS views. Now, the taxpayer did have an argument for this, right? There was an argument being done. The taxpayers tried to rely on the Palmer case and Revenue Ruling 78-197, the bright line for charitable gifts followed by redemption. Now, the IRS distinguished those two references you're going to find in the FSA because they involve gifts of interest that actually had value. Here, the charity had no rights and received no distribution. That interest was simply worthless. So, for the IRS, there is no charitable contribution deduction under Section 170. The deduction was wiped out on two separate grounds. Number one, intent. Using the Singer Company test, the IRS argued predominant purpose wasn't charity, but the substantial financial benefit of tax-free growth and personal use of the funds by the donor, or the theoretical donor, we should say. And secondly, there was a huge technical footfall, substantiation in this particular fact pattern. Number one, simple rule that will foul up a deduction very quickly. There was no CWA, contemporaneous written acknowledgement. In essence, they failed to attach, because this was also a, large non-cash contribution. They failed to attach a contemporaneous written acknowledgement. And even if they had, the charity couldn't certify exclusive legal control because the taxpayer retained it. They simply never got a CWA. That's bad. And secondly, there was no qualified appraisal. For a deduction of over $500,000, Section 170 F11D mandates a qualified appraisal. The taxpayers failed to attach one. But you might say, wait, publicly traded stock, you don't have to do that for that. True, but remember, they didn't give publicly traded stock. They gave non-traded LLC interest. But we disregard. No, we're not disregarding it. First thing is, they didn't own 100% of it anymore. In theory, they're arguing. But secondly, that's not. You put a wrapper around it. Valuation purposes, we definitely pay attention to, limited partnerships, LLCs, etc. That's a key concept. We talk about business valuation outside the, or I shouldn't say business valuation, but estate and gift tax issues. And remember, we're looking at that outside of, the whole context. We're not looking at the income tax side. We're looking at the actual value of what was given. And that value is not really going to be determined by the Internal Revenue Code. It's going to determine what a buyer would pay and what exactly would you pay to get a 99% interest that had no rights whatsoever in, I don't care how big the pool of money was. And that's kind of the big problem. So again, no appraisal, have a big problem here. So it's time to look at the conclusions and warnings you can take from this. First thing is, according to the FSA, the IRS is going to attack this on 3 different levels. They're going to go for economic substance is going to cause lack of economic substance, going to cause the entire transfer to be disregarded. It'll collapse the structure. Also, income was reallocated. The taxpayers paid tax on all investment income because it was assignment of income. That'll be attack number 2. And number 3, the deduction is denied, right? No charitable deduction is allowed by the IRS attack. And this is a tax shelter screen. The language in this FSA is aggressive. The IRS specifically labels this as a tax shelter scheme. And this is a warning for tax-exempt entities. The FSA suggests that charity was an accommodation party, a vehicle to assist the promoter. This invites scrutiny not just on the donor, but on a tax-exempt status of the participating charity. So, key takeaway from this is a red flag for any charitable LLC structure your clients might see marketed to them, where the donor keeps the checkbook and the charity get non-voting units with no mandatory enforceable distinct rights to cash flow. As I say, given the losses we've gone over the past year plus that have occurred in the conservation easement realm, where it's lost, we even talk about one this week again. Those who peddle tax shelters have to go on to the next big thing. There's a very decent chance this becomes the next big thing, and the IRS is going to attempt to nip it in the bud by telling you they don't like it. Does that mean they're right? Not necessarily, but it does mean you have to tell your clients that you got to expect you're probably going to have to litigate this thing if the IRS comes in and examines it. So you're watching on TV, I should say. I guess people do watch us on TV, your computer, or you've downloaded the slides. We now have the visual walkthrough of this here, a graphic that summarizes the purported strategy and the IRS's view, right? On the left side is what the IRS would claim was an illusion, right? The taxpayers create the strategy, shifting 99% of the income tax-exempt entity while using purported loans to essentially use the cash personally for whatever they want. Full access to the cash, they're in charge of everything, right? In the center part there toward the bottom, we look at the flaw. This particular thing, it represents the fact that, the padlock there toward the middle left, represents a continued asset control. This is fatal under economic substance. The taxpayer never really let it go. They never let go of the ability to use that stuff because they used it. That's a big problem. So on the right side of this illustration, we look at the overall verdict. When the IRS gavel comes down, and that is investment income, instead of being 99% tax exempt, it's 100% taxable to the taxpayer. The transfer of that unit and the related charitable contribution is disregarded. The capital account, it belongs to the taxpayer, not the charity, right? And the missing stamp highlights the lack of, substantiation. You got to substantiate. So there is a lot wrong with this. And almost certainly, if you had a situation that was identical to what's described in the FSA, you're going to lose. All the IRS had to go to was the lack of a contemporaneous written acknowledgement. This thing falls apart entirely as for the purpose of a charitable contribution. And assignment later income going to the partnership, that might be more of an issue. Maybe you still have a legit partnership even without the CWA. But again, it's highly unlikely under these facts, especially when they disregarded the operating agreement entirely. That's a really bad fact. But unfortunately, not a fact that you got to say you're never going to run into. Because remember, this is marketed to people believing that they're going to get this huge contribution and still effectively have full use of those funds or full control. It's my money. Okay, I agree. It's your money, which means it's taxable to you. Now, a charity, if they ever got under control or got pushed by the IRS, might sue an attempt to take the money from you, but that's a different problem down the line. So there's a lot that could go wrong in the transaction like this. So just kind of be aware of it. And certainly, the number one thing to be aware of is the IRS has, by publishing this field service advice, made it very clear they are not happy with the structure. Okay, let's go on to something a little different now. This is a major development for anybody in the cannabis industry because this is a Section 280 Cap E and how it interacts with the Employee Retention Credit. Since the Employee Retention Credit was enacted, there's been a lingering question, can marijuana businesses claim it despite Section 280 Cap E? Now, on January 30, 2026, the Court of Federal Claim gave its answer definitively in Gravenstein 116 LLC versus United States. And I will say I do not disagree with this holding. You can, if you take a really strained reading, you might be able to argue that this is an income tax credit, so maybe it's different. They're going through all these odd readings, but the Court of Federal Claims certainly didn't buy in on this, right? The Court of Federal Claims held that Section 280E is a total bar to any credit for a cannabis business. It rejected creative novel argument that the refundable portion of the credit was actually a non-tax refund and therefore isn't covered by 280 Cap E. And I've heard variants of this theory put forward. So let's talk a little bit more about the case. The plaintiff, the taxpayer in this case, operated dispensaries in California under the name Soulful, S-O-L-F-U-L. It is important to note the taxpayer admitted their business consisted of trafficking in a Schedule I controlled substance, marijuana, which is still there. I know we're thinking of rescheduling it, but during COVID, while ERC was available, it was always on Schedule I. So even if they reschedule it, that's almost certainly not going to change any result here. The taxpayers basically had claimed over $322,000 in employee retention credit for the first 2 quarters of 2021. And they filed suit and the IRS failed to pay the refund within 6 months. Remember, that's something you have a right to do. And in this case, probably it made sense to file the suit because IRS was certainly going to take their time paying it out and would likely deny in the end. So you're probably going to have to litigate anyway. So if you, in the off chance you win, it's better to litigate now and get your money today than to litigate, 3 years from now. And then, and then maybe win at that point. So the split argument, the taxpayers knew they had a problem with 280 Cap B. Because 280 Cap B explicitly disallows deductions and credits. We talk a lot about 280 Cap E disallowing deductions because that's usually been the big thing. But it also specifically denies those businesses credits, right? Tax credits. Their strategy to get around this, they attempted to basically split the ERC into 2 pieces. They conceded that the non-refundable portion used to offset tax liabilities might be barred. Remember, to go ahead and pay the payroll taxes that they had withheld, as well as the payroll taxes, as well as payroll tax on them. Depending upon which version of the ERC you're looking at, there were different things it's supposedly credited against. But if the total amount calculated was greater than that, which it almost always was, then you were able to get the rest refunded. And they argued that refundable portion, the check the IRS will send me, right, beyond the amount used just to offset the taxes, because presumably if you actually filed for the ERC not as a claim for refund, but on the 941, you just wouldn't have paid that much of your withholding tax, and you would have, therefore got it back. And if you had paid it, right, the theory would be, well, the refundable part would be still paid out to you, right? If you had paid it, you'd get that back. Well, they'll say, okay, that's okay. We don't get that back. We actually paid that. However, we should get back the amount you would have refunded, right? The amount that would have been refunded even if we hadn't paid any of those taxes that under whichever version of the ERC we're looking at were the taxes that, it would serve to first offset. So they claim that's not a tax refund or a subsidy for wages. It's basically, it was a non-tax refund. It was a subsidy. It was not a credit subject to 280E because it wasn't being used to reduce the tax. That's their argument. Okay. Now, the court starts out and looks at the statutory construction. And they're going to use a textualist approach. Judge Rommel applied the strict textualist interpretation. She looked at the plain language of the two relevant statutes. Section 280E states unequivocally that no deduction or credit shall be allowed to a trafficking business. And Section 3134, or its predecessor in the CARES Act and the CARES Act as amended, because officially 3134 didn't appear in the code until the third quarter of 2021. That statute calls it a credit against applicable employment taxes. It refers to it as a credit. That's why we call it the employee retention credit, right? It's a credit. And she applies the identical words canon. They applied the canon. She applied the canon. That the canon of construction says when identical words are used in the same statute, the Internal Revenue Code, they have the same meaning. 280E says credit off limits. 3134, when the ERC made its way there, but even before that, it uses the same words affecting the same Title 26 Internal Revenue Code. It's got to be the same meaning. Credit, credit. So if the code calls ERC a credit, it's a credit for purposes of Section 280 Cap B. She found no linguistic wiggle room here. Is credit's credit, you can't get credit. That's how this should be done. Now, what about the refundability and the non-tax refund? Remember, the taxpayer's theory was that the economic reality theory that a refundable credit often acts as a subsidy or welfare payment, like the earned income credit rather than just a tax offset. And they went to Supreme Court precedent in the case of Sorensen for Secretary of Treasury from 1986. In that case, Supreme Court held that refundable credits like the earned income credit are indeed treated as overpayment for collection purposes, but they remain credit for definition purposes. The judge noted that the Internal Revenue Code does not discriminate between refundable and non-refundable credits when it comes to definitions. And so the court said, we're looking at definitions here, and for definition purposes, a credit. And so she rejected this term non-tax refund, saying there's no basis in the code. It's a label the taxpayers invented to try to bypass the statute, and she wasn't buying it. Wasn't going to accept it. So finally, the policy arguments in this case and the court's conclusion. Now, the taxpayers argued that the CARES Act was remedial legislation to keep Americans employed during the pandemic. This argued the noble purpose should override the punitive nature of 280 Cap B. And I heard this raised a number of times on the ERC, right? Purpose, the purpose of the statute. You should pay attention to the purpose of the statute. Don't worry about those troublesome words over there. Just pay attention to the purpose. The judge refused to engage in perpervist. I love the term she borrowed. I guess that's a word, but it's like, perpersivist analysis. That's a neat term. When the text is clear, the policy goal doesn't matter. They enacted the text. That's what matters. In an interesting footnote, we get a cocaine comparison. Court addressed the taxpayers' attempt to distinguish the state law marijuana business from illegal cocaine dealers. Judge pointed out that marijuana is a Schedule I drug, while cocaine is Schedule II. Statutorily, marijuana is more restricted than cocaine. The court noted that this distinction does not reflect well upon the plaintiff. Right? You have the more restrictive drug. Now, we can argue about why that is and the weird reasoning behind the whole thing, but she's right that way. It's on the stricter list. So the outcome was the government's motion to dismiss was granted. The case reinforces that until Congress reschedules marijuana, amends 280 Cap B, or the regulation gets changed, tax credits are off the table. So again, we have our visual summary. And as I've told you before, I just create these with Notebook LM, tell them, okay, give me an overall picture of this case. and asked for it. So that's why you see Notebook LM's little logo down there in the corner. The standoff is on the left, right? It's a dispensary arguing the ERC is a direct subsidy. On the right, the IRS says on that left side, in legal standoff, the government holds up a stop sign. It says, wait, 280 Cap E acts as a stop sign. It bans all credit. Now, the verdict, judge goes with the IRS. Rationale number one that she uses is the plain text. This is a textualist view. The law calls it a credit. The law calls the ERC a credit. 280 Cap E says no credits. End of talk. We're done. Rationale number two is policy. Generally, the courts now, as they've moved more and more textualist over the years, are not going to normally allow a policy, social policy position to override plain law. Social policy cannot override the clear text of the statute. And that's something I've had to explain to people multiple times. The one case I had that was related to ERC, I had a nice long argument about it, was we talked about whether the owner of the business, owner of the S Corp, could their wages qualify for ERC? And the answer was if they had no living relatives, effectively. And does that seem dumb? Yes. I had a lot of people say that can't be their purpose. It's like, I don't care if it's their purpose or not. It's how the law reads. We are in an era where the courts tend to try to go to textualist, or at least try to argue they're going to textualist. Sometimes I've seen textualist arguments that seem awfully non-textualist. But you get there. That's the direction we go. When the statute is clear, in a case I brought up multiple times, Connecticut National Bank versus Germain, from the Supreme Court, if the text is clear, we're done with figuring out how this thing works. We don't care about Congress's intent. That's not the key one, right? So basically, nice little visual here about why the refundable argument failed. It's not going to overcome a textualist review of the statutes. And it's just clearly nowhere near doing that. Okay. Next up, we're going to talk about TEFRA intervention by majority partners. The issue here is a procedural battle in tax court involving a TEFRA partnership audit, which again, we're getting close to the end of these, but it still is useful reviewing the fact that you've got to follow procedures and you got to be careful here. The court questioner was, can partners who own a majority interest swoop in at the last minute to block a settlement that was negotiated by the tax matters partner? The case here is Walker Church Green, 819 LLC versus Commissioner, Tax Court Memorandum Decision 2026-11. Decision came down on February 3rd. Now, the answer was a resounding no from the tax court. The court reinforces that substantial showing required to intervene at the entry of decision stage is a very, very, very high bar. Regardless of how much of the partnership you own, that's irrelevant. If you own, I don't care if you own 10%, you own 99.8%. If you don't object early on, right, to what the tax matters partner is doing and you don't intervene early, then you can't swoop in at the very end when you don't like what the tax matters partner does. Let's take a look at the case background. This is another syndicated conservation easement case. This is a 2016 deduction year. The partnership Walker donated easement and claimed a $48.9 million deduction. Pretty much can guess how all this works because we've been down this multiple times. The IRS disallowed the entire deduction and asserted the 40% gross valuation misstatement penalty. There was a settlement eventually. After 2 years of litigation, the tax matters partner reached a deal in October of 2024. On the bad side for the partners, they agreed to a total concession of the charitable contribution deduction. The good side was the IRS agreed to reduce the penalty to 10% from 40%. Now remember, that 40% penalty is mandatory. You go to court and you lose on that, you're going to pay 40%. The IRS is willing to settle this case and get it basically off their plate. They were willing to go down to a 10% penalty. So 10% of the tax savings would be added on to the tax, right? They also would allow an $11.2 million other deduction, which related to the funds that the partners had put in to this thing, and it would not be subject to the 2% floor. When negotiating a settlement, those are all options. You are never going to get that in exam because an agent has no authority to ignore the fact the penalty is 40% and to ignore the fact that you need a 2% floor in 2016. We had that rule there. Right? Now, 6 months later, when the IRS moved to enter the decision, a group of 40 partners who collectively own nearly 63% of the entity filed motions to intervene and reject the deal. They didn't like it. They're going to have to pay. And they're going to pay substantially. Now, it's less than they would have paid if the 40% had been there, and they wouldn't have been allowed to deduct the amount they invested, which actually seemed like there was a reasonable chance we'd end up there. Right? The IRS is just getting this off the plate. Okay. Now, the legal standard to intervene under TEFRA. Right? Under TEFRA, the goal is to resolve issues in a single proceeding. The partners had rights under TEFRA. We're no longer under TEFRA. Now we're in the BBA, and these are different. But under TEFRA, there were a couple of rules, and following rules is the key takeaway from this. Under Rule 245B, partners can elect to participate as of right within 90 days after petition being served. So you just automatically can jump in and intervene in the case if you are, a notice partner within 90 days petition being served, right? So basically, they could jump in. These partners missed that window by 3 years. They decided to let it go forward and let the tax matters partner continue to run this thing. At that point, had they jumped in then, there'd have been no question. They're allowed in. They can take it over. They didn't do it then. Rule 248B says when we are at the entry of decision stage settlement, then these partners need leave of the court to intervene. And the court cites the Chimney Rock Holdings and Bloomquist Holdings cases for the standard you'd have to meet to be allowed to intervene. To get in this late, you must make a substantial showing. It's not enough to just say, I object. That's a key takeaway. Now, deficiencies in the motion, right? Why this failed? Judge Pugh dismantled the partner's motion on 3 specific grounds. Number 1, there was no substantive objection. The partners failed to argue the settlement terms were unreasonable, didn't claim the $11.2 million deduction or the 10% penalty was a bad deal compared to the risk of trial. They just wanted to go do a better deal, effectively. Number 2, they were the lack of preparedness. They claimed they were prepared to litigate, but the court looked at the docket and saw no expert reports or valuation theories. In a complex valuation case, you can't go to trial without the experts being in line. The court noted they shouldn't be allowed to disrupt the settlement without a concrete plan. They just wanted to, they didn't like the check. So they're it kind of gives a position you're scrambling. And if we grant you relief to come in, we're going to extend by a long time period how long it's going to take to settle this case. And number 3, there was no fiduciary breach. Well, at least they didn't allege that the tax matters partner had misconducted himself or had breached fiduciary duty in accepting the settlement. Those 3 things mean no way you're getting in. Now, but the partners said, wait, we're the majority owners of this thing, right? We own it. Well, the primary's argument was kind of unique. They own 62.27% of the partnership. Surely the majority owners have the final say on the settlement, right? But the court held this distinction does not change the conclusion. TEFRA says nothing about that, right? The rationale, the court emphasized these partners had 3 years to join the case. They could have done it without anybody being able to stop them within that 90-day time frame. And they could have tried to come in earlier, but they waited till the last second, right? They sat on the sidelines while the tax matters partner litigated the case. So the conclusion was you cannot rely on your ownership percentage to cure procedural failure. The substantial showing standards applies to everyone equally if you're a 10% partner or if you own 95% of it. If you allow the TMP to go forward and you let the case move on, and then at the last second, when you don't like the deal the TMP was able to get, you try to basically say, no, let us back in. We want to go do this again. You're not going to be let in. If you want to control litigation, you must elect to participate at the beginning. Certainly not at the very, very end. The longer you wait to get in, the more difficult it'll be to be let in this case. So again, we have our slide with the summary here of what it looks like. And you see the deal there on the scale, right? We got there, right? On the left side, the TMP secured a reduction in penalties, 40% down to 10%, $11 million to deduction. The IRS and the TMP were in agreement. On the right side of the scale, we have the holdouts, right? The objective partners represent a majority, but they are blocked by a substantial showing barrier, which is on the left half of the slide. Why they failed? This is the judge's reasoning, right? The empty checklist shows they simply weren't ready to litigate, right? We just don't have that there. And there was no allegation of TMP, there was misconduct on part of TMP that just wasn't alleged. The TMP acted properly. So in the bottom right, they cite their precedents, right? Chimney Rock, I'll get that right. Bloomquist is a growing line of case where a tax court denies late-stage intervention in these conservation easement settlements. They want them out of here. If you snooze, you lose. And you can't jump in the last second. We're seeing this happen a few times because these are getting to the end game now. And obviously, the partners don't like the result. And so they're scrambling to try to somehow change the result. And practical matter is they're not really going to get it changed. Next up, substantiation of research and development credits, right? This is the case of the battleground here is substantiation. This case of George versus Commissioner, Tax Court Memo Decision 2020-610, decision came down on February 3rd. Now, it's a substantial memorandum opinion involving a large, vertically integrated poultry producer. Judge Greaves opened the opinion with a memorable line that frames the entire dispute. He says, gotta love good judges who like to write good first lines. Forget the proverbial chicken or the egg. Today we're called to answer which came first, the research or the research credit study. Did the research credit study just document research taking place, or did we end up, the research credit study was what created out of whole cloth a theoretical research project? And that's how this thing's going to be analyzed. In this case, critical lessons on the difference between a retrospective study claims and what the contemporaneous records of the taxpayer actually showed was going on. So which came first? The taxpayer. This case involves Georgia, Missouri, GOMI, you'll see it referred to, a massive poultry business operating on high volumes and low margins. Tradition for the industry. They use data analytics constantly to ensure uniform broilers, the chickens, right? The timeline. GOMI didn't claim R&D credits on their original returns for 2012 to 2014. In 2014, they hired a firm, Alliant Group, which will turn out to become an issue the IRS tried to litigate here, to conduct a retrospective study. The study identified various projects involving feed additives, vaccines, and genetics. They defined the business component as an improved poultry product, a better, healthier chicken. The conflict was the IRS argued these weren't research experiments. They claimed the study took routine production data and tried to twist it into a bunch of Section 41 claims after the fact. The court had to decide if the study reflected reality or created fiction. You're going to find out the court decided there were parts of both. Let's look then at the general legal framework here. We're going to look for this issue. Under Section 174, a key issue here was the pilot model concept. And the court provided an analysis of the pilot model rules post-2014 regulations. The rule: if you construct a product to test the concept's viability, the costs represent deductible R&D. That's the pilot model. The application here, the chickens themselves were potentially the pilot models. If the taxpayer was testing a new feed to see if it worked, the cost of the feed and the chickens eating it could be QREs, qualified research expenditures. And then Section 41 requires a process of experimentation. In essence, you need a systematic trial and error process designed to eliminate uncertainty. The real world constraints on this is the IRS often argues if you don't have a perfect control group, it's not research. Now, the court rejected that blanket statement. In a commercial setting, you often have to integrate the test into production. Integration of variables because you can't shut down the factory to test. That's simply real world. The court was not going to strictly require a separate control group running. And so we get to the mixed basket of results. Because it wasn't all one or all the other, right? The judge called the taxpayer's claim a mixed basket of eggs. He loves continuing, all of his sort of cute wording throughout this opinion. Some were good and some were rotten. Then we're using the egg here, right? The rotten eggs, the disallowed. Well, in some cases, we looked at contradictory evidence. They looked at the salicylate and phytase projects. These studies claimed they were varying dosages to find the optimal amount, class experimentation. But the contemporaneous feed log shows the dosage never changed. Didn't look like experimentation. The lesson: if your study says one thing, we experimented, right? And your daily logs say another, we did the same thing every day, the study's going to lose. This is the chicken before the egg. The study took place and then tried to invent research. But there was no research. You had to go back and do it. The chicken came before the egg. Now, good eggs, for example, the sporulin and calsporin cases, right? Here, the records showed a clear scientific method. They had a hypothesis, they ran a test, they analyzed the data, and when it failed, they moved to a new product. And this says Ross 708 Genetics is the cleanest example, right? What they had there. They had a new genetic line against control group and analyzed slaughter data. So those were two good egg sets, right? The timing trap, hatchback. The court disallowed the credit for 2012 because uncertainty existed. Because the 2012 test was successful, the court disallowed the 2013 cost. Once you know it works, we're done with research. So you have to watch for that too. So there's a partial throw out there. That was, I guess, the half good, half rotten egg in this whole situation. So finally, we got to what turned out to be a little bit more of a problem for the taxpayer, the base amount, and what turned out to work out well for the taxpayer, the penalties. Okay, the technical blow, they really got hurt. There was a base amount failure. To calculate the credit under the alternative simplified credit method, you need qualified research expenditures for the 3 preceding years, the base period. The taxpayers did not have detailed records for 2009-2011. They tried to estimate these amounts using a ratio from the current years. Courts have not liked that option. That's one that if you're using that, it's getting much more difficult to make that, try to run that through the courts. The court refused to apply the Cohen rule to estimate the base. They said essentially, without evidence, the base was deemed to be zero or insufficient. Because use Cohen, there has to be enough evidence to reasonably estimate. And the court's not allowing Cohen in this case. They've not been finding that. So that forced them to use the startup limitation. And this reduced the credit calculation from 14% of the excess down to just 6% of the current QREs. That's a massive reduction in this case in the credit value. Now, the good news for the taxpayer was on penalties. The court declined to impose penalties. Unlike in the Betts case, the court found reliance on Alliant Group was reasonable because the study was comprehensive, 100 pages, and the taxpayer gave the firm full access to their data. The IRS literally tried to say, well, you use a consultant group who was found in this case, to have had an unreasonable study. That must mean yours is unreasonable. As we're going to discover in a later case, that kind of, by allegory is not going to work. Yeah, the fact that there was something bad in that case, and let's assume there was for this consultant you had, that doesn't mean there was something wrong in this case. And again, they didn't get, they only got partial, but the court did not find that it was improper to have relied upon the Alliant Group. So using them is not per se just, sorry guys, if you lose, you're getting penalized. They're saying no, it was reasonable in this case. You have to take each case on its own. So finally, the visual again, right? On the test side of this, on the left side, right, we see three hurdles: Section 174 uncertainty, the process experimentation, and the product definition, right? On the right side was the outcome, right? Green check, Ross 708 worked because he used control groups and data. Red check, FITs failed because contemporaneous records, the scales didn't match the study's claim. The bottom center, the problem of the 6% hit, right? That coin icon down there represents the financial impact of failing to substantiate the base period. Instead of the full credit that they tried to claim, they had to cap themselves at 6% startup rate. And so the key takeaway is you can't just retroactively find a credit all the time. The study must align with what actually happened on the factory farm floor. You need evidence of experimentation at the time that you were trying to resolve an uncertainty through experimentation. You can't just kind of look back there and said, well, that could have been, if it rearranged slightly, it would have been experiment. No, you can't really do that. That's not going to work for you. Okay. Next up, talk about supervisory approval of penalties, a case something's become big. But in this case, the claim the IRS did not have proper supervisory approval was essentially the proverbial, I'm recording this the day before the Super Bowl, Hail Mary pass. You know, trying to save something from the case. And this is a tax court order from docket number 1749-23. It was issued on February the 5th, 2026. Now, we don't often cover orders of the tax court, but this one got a lot of notice because specifically of the judge's rather harsh language the judge ended up using in this case. So this is the procedural world of Section 6751B. The requirement that IRS supervisors must approve penalties in writing. Been a lot of litigation about this in recent years, right? In this case, Palmwood Holdings LLC versus Commissioner. This is a designated order from Chief Justice Erta, which gives us significant weight on procedural matters, right? The key question: if the IRS asserts a penalty for the first time in the answer, lawsuit pleading, what constitutes the initial determination and the written approval? And the court said, look at the signature block on the pleading. Basically how we come up with this. Okay. So let's talk about the procedural context of this. Underlying case, this is yet another syndicated conservation easement dispute involving, in this case, $44.9 million deduction on a 96-acre tract. The timeline, the IRS issued the final partnership administrative adjustment, and the taxpayer petitioned the court. The twist: after the petition was filed, the IRS decided to up the ante, which they can do. Right? This is a risk of going to tax court. In their answer, they asserted the 6663 civil fraud penalty. That's really nasty penalty. Okay. Now, the requirement under Section 6751B, a penalty cannot be assessed unless the initial determination is personally approved in writing by the immediate supervisor. Now, the IRS moved for partial summary judgment, submitting declarations that the trial attorney, Richard Wooldridge, made a determination as supervisor is Melissa Lang, and Alexandra Nicolates, sorry, Alexandra, for mispronouncing your name, approved it. Now, the taxpayer's challenge was based on the objection. They didn't have concrete evidence that the approval was missing. Instead, they claimed they had reason to believe the IRS declarations were untrue. The evidence, they pointed to a 2021 email chain from a completely different case. Shades of Alliant Group, of the Alliant Group shade the IRS was throwing in the case we just discussed, involving different taxpayers. Hey, Alliant Group back again. There, this old email suggested IRS attorneys might misrepresent who made determinations. They asked the court to deny summary judgment, open up discovery so they could depose the IRS attorneys and investigate the internal approval process. In essence, the judge's view, they wanted to go on a fishing expedition. They had no current evidence of, improper conduct by the IRS. The IRS had, because remember, the IRS now has submitted an answer that says, we had the approval and it happened like this. The court is going to say, if that's the case, if they actually did what's said here, right? Then that would be it. And they have this evidence. You're just telling me I need to assume the evidence might be wrong? Okay, the court relied on Bell or Woods. In the context of tax litigation, Penalties raised the answer is the initial determination. So then there's a black and white test. The court looked at the document itself. The answer was signed by Mr. Wooldridge, the determiner, and his two supervisors. The court held that signature block is conclusive. Supervisor's signature on the pleading constituted written approval, required written approval. And relevance. The court held that any prior internal emails or discussion are irrelevant. The statute requires approvals of determination, which is the formal filing of the answer. That's the key issue. And now, what got this thing written up based on tax news sites? The admonition. The Chief Judge Erda did not mince words regarding the taxpayers' tactics. He characterized requests for discovery as being based on wild speculation and being wholly ill-conceived. And this order is a warning to practitioners, basically those who are litigating the tax courts. And while most of us, CPAs, EAs, are not, we haven't taken the tax court exam, so we're not litigating in tax court. There are a few of you who do, and there are some attorneys maybe listening here. So this is one that's basically referenced for the attorneys. Accusing officers of the court, IRS counsel, of lying is a serious charge. If you make that accusation without strong support, you risk, per the court, losing your credibility with and the patience of the court. Don't do that. Upsetting a judge is usually not a good strategy in most cases. Just going to say that. Outcome, the IRS motion was granted, and the penalties are procedurally sound. Again, we're not going to open up discovery. In essence, we've decided that they've been basically applied procedurally correctly. That doesn't mean you can't argue they shouldn't apply, but it means you're not going to get the automatic win of saying that the approval wasn't there. You're not going to be given the right to go on a fishing expedition to try to find something that you could argue shows that. So again, our graphic for this one, and again, divided into nice two parts, right? Here. You can see that this particular case, there's the facts in the case, so you know what was there. They originally purchased 839.6 acres for just over $2.5 million, and actually donated only 96.6 acres, but claimed nearly a $45 million deduction. Standard conservation easement case, and unfortunately, standard conservation easement result at the end of the IRS exam. IRS disallowed everything and eventually decided to go after a fraud penalty. Right? And they're saying that this is so far out of line, we believe it's fraudulent conduct. If basically fraud was committed by returns that claim this big deduction. Right? Now, the mechanism, it takes a look at the signatures on answer, right? That's what we're looking for here. Right? These are things that actually do it, right? The takeaway is supervisor signs the pleading. Section 6751 is satisfied in this case. The verdict, the judgment was granted. The IRS won a procedural argument. Court shut down the attempt to look behind the curtain based on unrelated emails and your suspicion that had no direct evidence that tied it to this case. Just as the IRS got slapped down about going after Reliant Group, or Alliant Group, I should say, not Reliant, Alliant. Apologize to Reliant. Reliant Group, no. That's, they may have done something in that case and fine. In that taxpayer, everything is okay. In that case, then the penalty's applied, but that doesn't mean they're just going to automatically, have to be disregarded. And the same thing here. You're not going to be able to automatically just disregard, what IRS attorneys are signing and claiming about having timely approval, absent, having some evidence about why that's not right. So it is becoming a harder defense to wield, the 6751 defense, because the IRS is now aware of it and how it's going to work. And that's especially when the IRS follows formal steps correctly in litigation. Doesn't mean you can't win on it, but it does mean it's not shooting fish in a barrel the way it kind of was early on. Because again, IRS didn't pay attention to these things. Next up, we're going to go to an ERISA case. And this is one we see every so often. And unfortunately, there's this thing called ERISA preemption. And ERISA preempts any state law rules that may attempt to come to a different decision. And this is the case of Packaging Corporation of America's Thrift Plan versus Langdon. And this deals with ERISA beneficiary designations and changing them. And this is really important because we have seen this. By the way, it often comes up in life insurance programs that are employer sponsored. We see it go wrong there quite often too. And there quite often, people think, and even some attorneys believe initially, that local law that says once you get divorced, any designation of your spouse, your previous spouse, as your life insurance beneficiary is immediately voided. ERISA preempts it, right? ERISA preemption, if the plan is covered by ERISA, 1974 law, it's been amended multiple times since. It's, the federal rules are what matter, not the state rules. So if you have a client going through a divorce, this is a critical reminder: divorce decree or letter to the employer is almost certainly not enough to change a 401k beneficiary. You must follow plan procedures. This case came out of the Seventh Circuit. It's case number 25-1859. Came down on February 2nd of this year. The court addresses substantial compliance doctrine. Can an informal written request override specific positive action requirements like logging onto a website mandated by the plan documents to change your beneficiary? So let's look at the factual backgrounds of this case, right? So let's go for the setup. Decedent Carl Kleinfeld had a 401k with Packaging Corporation of America. In 2006, he designated his then wife, Danae Langdon, as a primary beneficiary, right? Now, the plan was very specific. Change of beneficiary, you had to either update it online or call the benefit center. Okay? So let's go forward to September 2022. After the couple's divorce, in a couple divorces, a qualified domestic relations order is executed, splitting the retirement funds. In October of 2022, Kleinfeld instructs his secretary to fax a letter, not go online, not call the benefit center, but fax a letter to the benefit center. Letter explicitly says, remove my former spouse from the insurance and 401k, and send me any forms I might need to complete. Now, the quadro was, the amount that was to be paid out to the former spouse on the quadro, that was followed. The fight's over the rest of the funds, because what happened there was, while PCA updated his insurance, PCA is Packaging Corporation of America. I actually know that because years ago I had a client that was involved with that was PCA, well, a part of what's no longer PCA, but still there. So yes, Packaging Corporation of America, PCA. It's a fairly big organization. While PCA updated his insurance, which likely allowed paper changes, but did not change the 401k qualified plan beneficiary. Now, Mr. Kleinfeld died 3 months later in January 2023, and no further action had been taken before he died. The question now becomes, who's the beneficiary? Who gets the money that's not, we know that, his former spouse gets the quadro amount. Who gets the rest of the balance of the plan? Now, the estate, represented by his sister, argued that the facts proved Kleinfeld clearly wanted the ex-wife out. And the district court, who tried the case initially, agreed, and it ruled the facts constituted substantial compliance. The ex-wife appealed to the Seventh Circuit, right? The Seventh Circuit had to determine if substantial compliance doctrine saved the day, and basically the sister will get the money. We all agree pretty much that he wanted the sister to have the money. But ERISA essentially does not want to be playing on us arguing over intent. They want the plan to have very clear guidance on what to do. The plan sets out rules. You must follow the rules. If you take one thing away from this discussion, it is if the plan has, if you want to change beneficiary, you got to go find the detailed plan rules and you got to make sure they're followed exactly. That's a takeaway because this is not the first time this issue's come up, right? So they noted legal uncertainty, right? The court first noted Supreme Court's Kennedy decision, which generally demands strict adherence to plan documents. The plan administrator must act in accordance with the documents. However, in an interpleader case where the company isn't at risk of double payment, the doctrine might still apply. The test. Now, we're not sure if the doctrine exists of substantial compliance, but maybe it does. The court said it's possible. So we're going to go ahead and presume it applies because it turns out it won't make a difference. If it doesn't apply, the ex-wife gets it. And the court's going to say if it does apply even, you don't pass the test, so the ex-wife gets it. So first, you have to have evidence the decedent wanted to make the change. Well, that's a given here. We got that. But there also must be positive action. The deceased must have taken steps for all practical purposes similar to the required action. That's where the Seventh Circuit has a problem. Okay. So while Kleinfeld had the intent, the facts were unambiguous. He wanted her off the plan for anything beyond the quadro. He failed on part 2. That fell apart on positive action. The plan required an online login or phone call. It never authorized changes via fax. That was found to be a material deviation from the requirements, and that's going to fail the positive action plan. Now, the estate tried to rely upon cases like Davis or MetLife. In those cases, the decedent used the correct form, but made minor clerical errors like forgetting to date it. The Seventh Circuit panel said sending a fax when the rules say log in is not a minor error. It is a material deviation from the required procedure. You aren't substantially complying with an online portal requirement by sending a piece of paper in. And note, that's also important because you can't do that. You can think a little bit about this, not that it would apply because it's not really ERISA, but you might see the same concept applied if your client is trying to get that direct deposit refund. IRS says you got to go online. You don't substantially comply by asking for it to be sent paper. Of course, you do that, the day's probably going to run, and who cares? They're not going to get it on the bank account because you want to tell them the account number, either over the phone or by writing in. Nope, you're not going to get it. So again, that's not substantial compliance with the IRS's rules under the executive order. A little different. This is a bit stronger. The ERISA is a bit stronger in this rule, but same sort of concept. And the court also said there was self-awareness for the failure. The court found a smoking gun, in their view, in the fax itself. Kleinfeld asked the plan to fax him any necessary paperwork. To them, the meaning was he knew he wasn't done. He knew there were more steps. He just never followed up. Holding because he failed to take the specific positive action required by the plan, his attempt was legally ineffective. The result, the ex-wife, despite the divorce and the clear intent to remove her from the non-quadro portion of the plan, remained legal beneficiary of the entire 401k. So, takeaway, never let a client rely on a letter or anything informal divorce decree or a fax. Advise them to find out what the plan itself requires. Preferably get something in writing from HR that says the plan requires you this, this, and this, and follow that. But I would also suggest, even better, checking the plan document. Might not be a bad idea to say, your counsel should probably review this because, look at these cases, and then they might want to go through with you reviewing the plan documents to find out exactly what you're being told to do this, because you got to get this right or your ex is going to remain the beneficiary, which is probably not what you want. If the plan says click here, you got to click here. And again, our final nice little graphic. This one's really got a lot going on it. It's very, 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 very full. So busy, I guess we're going. You might want to get the download and look this one on your own, although you can follow it on the screen if you want. It's there. In the center, you see the balance of the substantial compliance doctrine, right? Evidence of intent on the left was heavy and clear, but the positive action, the right side, was light because you used the wrong method. And why the request failed, the right side, it was, the icon shows a fax machine versus a computer. They're different, right? The court ruled these were not similar for practical purposes. I know what a fax machine looks like. We still have one because I think we have like 2 clients who still insist on faxing us stuff. Aside from those 2 clients, we never get a fax except for all the ads. But so much fun. We still have them, though. Clients have trouble changing their ways. But as we're going to discover, and this case kind of illustrates, it's going to get more and more difficult for those that don't want to do things online to be able to function. As we talked about, you can't fix the lack of electronic filing information return by calling IRS. You have to go online. There are just certain things that had to be done online, and it's likely to become more of those things, not less. That's the way it goes. Also, remember they had recognition that there were further steps. He asked to send me the paperwork, right? This confirmed he knew the fax wasn't the final step. And therefore, he knew there were steps to come. That's what the court reasoned from that. And he never followed up to figure out what those were. Now, I'm sure counsel for him, counsel for the estate and for the sister was arguing, well, he just assumed that it must have been, he must have submitted everything he needed to because they didn't contact him, but that's probably not a good assumption to make. So, in essence, what happens there at the bottom, there at the very bottom on the right side, is there is a careless error, right? Or I should say the table at the bottom. A careless error which the courts may forgive, with material failure which the courts will punish. A fax instead of a login was held in this case to be a material failure. You would prefer your client not try to argue substantial compliance. Tell them we want to argue that you did exactly what was said. If you do it the other way, your ex is going to get it. By the way, for a lot of people, that'll be highly motivating, right? Your ex is going to get it if you die. They're going to take it away from, whoever you're trying to give it to instead of the ex. That's a motivating factor. So keep that in mind. And probably divorce counsel should keep this in mind. Be careful here because you got to remember that you're basically in an area talk about employee benefits that's not really state law. There's federal law that also applies. This is what always makes it tough for everybody, and also why attorneys get paid the big bucks, right? It's complicated. The good news for those of us who are CPAs and EAs in tax is that we primarily stick over in Title 26 United States Code. And if anything drifts outside of there, then we know it's time to go get the attorney involved and get more things involved there. But realize we can have the same problem of blindness, not realizing there may be things other than Title 26 U.S. Code that apply. So always warn your clients that I can tell you what the code says, what the law says for taxes, but there might be other laws that you really, really, really better be considering. And you should seek legal counsel because when I tell you about forming an LLC versus incorporating, I'm going to talk it from the tax standpoint, but there are huge legal differences between a state law corporation and a state law LLC. And while there are tax quirks that sometimes attorneys that are into the state law structure won't understand, especially about the one class of stock rule if that LLC wants to make an S election, conversely, there are huge chunks of law that if you're just on the tax side, you're not going to understand about those other things. Try to make sure you understand that there may be other factors that become involved. But at least in this case, I would think attorneys, because a lot of clients they are going to have retirement plans with employers with ERISA plans, probably be a good idea for them to be up to speed on ERISA. Just saying, one of those things. Okay, this concludes our updates for this week, February the 9th, right? We have a clear trend today, where substantiating research and development credit, following the ERISA plan documents or adhering to TEFRA intervention rules, the courts demand strict compliance with procedural formalities quite often. And by the way, it's much better always to not be arguing that we were close enough. Try to make sure you get your clients to stay clearly on the side of following the formalities. We don't want to have to, in essence, as has been pointed out a couple of times, you talk to people, well, could it work if this and this were true? It's like, maybe, but why in the heck would you ever allow a client to get in the position we're asking this question? Is probably you're going to try to stop it. Substantial compliance or intent is often not enough to save a tax position or to save your beneficiary designation, right? You need to be there. Now, if you have any questions or you need to follow up on this week's developments, you can email me there at the address on the final slide, edzollars@currentprotectiondevelopments.com. I also will be on the Connect sites for New Jersey, Arizona, Minnesota, Illinois, Idaho, and Washington. So if you have any questions, you can post them there. And if I see something, I'll try to follow up. I want to thank you for joining us this week. And we look forward to seeing you next week for more developments in the area of federal taxes.